Breaking news: Supreme Court delivers rare 9-0 unanimous ruling. In a moment that would soon be etched into the nation's memory, the news broke with the force of a thunderclap, sending shockwaves through every corner of the country. The headline flashed across every screen in the nation. From bustling city centers to quiet rural towns, Americans everywhere paused, transfixed by the gravity of what was unfolding. The story dominated conversations, social media feeds, and dinner tables alike. In a deeply fractured America, the 9 justices of the Supreme Court spoke with a single, thunderous voice. For a brief moment, the usual divisions, political, ideological, generational, seemed to fade as the country turned its attention to the court's rare display of unity. The decision came down on a cold January morning, storm clouds looming over the Capitol. The case, United States versus Digital Citizens Alliance, was expected to be another 5-4 split. The air was heavy with expectation, as if the city itself sensed the magnitude of what was about to happen. Pundits were wrong, reporters huddled outside, anticipation thick in the air. Inside, the Chief Justice read the opinion. This was no ordinary ruling. The words carried a weight that was immediately felt by everyone present, echoing through the marble halls and out into the waiting world. The case questioned the government's power to access personal data from tech companies and the very nature of privacy in the digital age. The justices, often divided, sat united. Their faces were solemn, aware that their decision would shape the future of privacy and technology for generations to come. Their decision was a powerful, unequivocal statement redefining government authority. The ruling struck down a controversial surveillance program and set a new precedent. It was a moment of reckoning, a clear message that the Constitution's protections must evolve alongside technology. It declared that digital life, emails, messages, location history, was protected under the Fourth Amendment, just like a physical home. For millions, this meant that their private conversations, memories, and movements were no longer vulnerable to unchecked government intrusion. The government could no longer demand this information without a warrant. It was a stunning affirmation of individual rights in a time when they felt under siege. Privacy advocates celebrated, while officials scrambled to understand the new legal landscape. The news spread instantly. Emergency meetings, phones ringing, chaos on Capitol Hill. The storm outside broke as the ruling was read, a metaphor for the political storm about to follow. Lawmakers, lobbyists, and citizens alike rushed to grasp the full impact of the court's words. The implications were immediate, far-reaching, and deeply shocking. America had just witnessed a constitutional earthquake. The ground beneath the nation's digital life had shifted, and nothing would ever be quite the same again. To grasp the magnitude, consider how rare a 9-0 decision is on a divisive issue. The modern Supreme Court mirrors the nation's divisions. 5-4 splits are the norm. A unanimous ruling signals that the legal question transcends politics. All 9 justices, appointed by presidents from both parties, agreed. Digital privacy is a fundamental American right. This wasn't compromise, it was consensus. Such unity gives the ruling immense moral and legal authority. Unlike narrow decisions, a 9-0 precedent is nearly impossible to overturn. The court didn't just resolve a dispute, it drew a bright, clear line for the digital age. This is constitutional bedrock. Legal experts across the country are stunned, not just by the rare unanimity of the decision, but by the bold and forward-thinking reasoning the court used to reach its verdict. The ruling introduced a groundbreaking concept, the digital curtilage doctrine, which extends the Fourth Amendment's protections, traditionally reserved for physical spaces like homes, directly to personal digital data. In essence, the court declared that your digital life, your emails, photos, and messages, is now considered as private and protected as the 4 walls of your home. The outdated third-party doctrine, where simply sharing data with companies meant forfeiting your privacy rights, was decisively swept aside, marking a dramatic shift in legal thinking. The justices recognized that in today's interconnected world, modern life requires us to share data constantly, but that necessity shouldn't mean giving up our fundamental right to privacy. The focus of legal protection shifted from simply asking who holds the data to examining the nature and sensitivity of the data itself. If the information paints an intimate portrait of your life, your relationships, or your private moments, it's now protected, regardless of whether it's stored on your device or in the cloud. This is more than just a legal update. It's a fundamental rebalancing of power between citizen and state, redefining the boundaries of government access in the digital age. The digital curtilage doctrine marks the beginning of a new chapter in constitutional law, one that will shape privacy rights for generations to come. The case centered on the Digital Privacy and Sovereignty Act of 2023. Ostensibly to protect Americans' data from foreign threats, the law gave U.S. agencies sweeping power to seize user data without a warrant. The government claimed it was vital for national security, Civil liberties groups and tech companies argued it was a breathtaking overreach, collecting data on millions of innocent Americans. The Supreme Court sided with the challengers, striking down the Act's key provisions. The court ruled that accessing comprehensive digital records is the modern equivalent of searching a home, requiring a warrant and probable cause. No more warrantless mass data collection. Your digital footprint is now your private domain. The impact was immediate and chaotic. Surveillance programs built on the Act's authority were instantly illegal. Federal agencies halted operations overnight. State and local laws modeled on the Act were now constitutionally suspect. District attorneys scrambled to review cases, as evidence obtained under the old rules became inadmissible. For Americans, the change is profound, but invisible. Your digital life is now shielded from unwarranted government intrusion. Civil liberties advocates called it the greatest privacy victory in a generation. Law enforcement warned it would make tracking criminals harder, reigniting the privacy versus security debate. The court chose liberty. Now the nation must grapple with the consequences. Legal experts across the country are calling the Supreme Court's ruling nothing short of revolutionary, a true constitutional reset that will be studied for generations. Many say it marks a turning point in how the law views privacy and government power in the digital era. United States versus Digital Citizens Alliance now stands as a landmark case, joining the ranks of Marbury versus Madison and Brown versus Board of Education. Legal scholars are already comparing its impact to those historic decisions that fundamentally reshaped American law. In a bold move, the court rejected decades of its own precedent, decisively dismantling the third-party doctrine after more than 50 years. This doctrine had long allowed the government to access personal data held by third parties with minimal oversight. As one prominent law professor put it, the court chose to be right rather than consistent. Experts agree that this willingness to break from tradition signals a new era of judicial independence and courage. For nearly 2 decades, the executive branch steadily expanded its surveillance powers, often with little meaningful oversight or public debate. This unchecked growth raised serious concerns among privacy advocates and constitutional scholars alike. With a rare 9-0 decision, the court has ended that era of deference, reasserting the judiciary's vital role as a check on government power. The unanimity of the ruling sends a powerful message about the importance of constitutional rights. The ruling's historic unanimity gives it extraordinary weight, aiming to settle the digital privacy debate once and for all. Legal analysts say this clarity will shape future cases and guide lower courts for years to come. Now, lawmakers must operate within this new, clearly defined constitutional boundary. The decision challenges Congress to update laws and policies to reflect the court's strong stance on digital privacy. This is more than just a legal opinion. It's a course correction for the nation, signaling a renewed commitment to individual rights and the rule of law in a rapidly changing world. The digital age now has a new constitutional foundation, one that will influence how Americans live, work, and communicate for generations to come. The Supreme Court's halls are quiet, but the shockwaves are just beginning. The digital curtilage doctrine opens vast, unexplored legal territory. New legal battles will define the boundaries of digital privacy, across borders, smart devices, and emerging tech. Congress faces pressure to craft new laws that respect the court's ruling while addressing security concerns. The political fight will be fierce, and the national conversation, unavoidable. January 24, 2026, marks a new chapter in American history. The ruling is not the end, but the start of a new era. The meaning of freedom in the digital age will be shaped by what comes next.